And thank you, Mr. Chairman, and I thank you, Chairman Raskin, for holding today's hearing on a question that couldn't be more important to the American people or fundamental to our nation's identity as founded in our Constitution, the ability of people to be secure in their property. In the case of civil asset forfeiture, there's no requirement that the property owner be convicted of a crime, let alone charged with any sort of offense. And I want to quote this morning, first of all, my hometown newspaper, the Charleston Post and Courier. As we were discussing earlier before the hearing today, I worked on civil asset forfeiture as a state lawmaker before coming up here to Congress, and it's an honor to work with you on these issues and to have this hearing today. It's an important hearing. The Post and Courier a few years ago reported on investigations by the Post and Courier and the Greenville News in 2017, and their investigation showed how the law was incentivized law enforcement agencies to seize assets, sometimes without even filing criminal charges, and put people in the legally backward position of having to prove their innocence to get their property back, which is completely opposite of what the Constitution would, I believe, require. The Post and Courier also stated the Greenville News series that did this large investigation looked at some 3,200 seizures and $17.6 million in assets taken over a 3-year period in South Carolina. In about 800 cases of those 3,200, or 25%, there were no criminal charges filed, and in another 800 cases in which charges were filed, there were no convictions. The series, the investigation by the Greenville News, also found that roughly 2/3 of seized assets came from black men, calling into question whether the law was being applied fairly. And as the chairman rightly recognized, this disproportionately affects communities of color, and those who are poor are also unfairly and unevenly treated in these cases. The writers of our country's Declaration of Independence held several truths to be self-evident: that all are created equal, that they are endowed by their Creator with certain unalienable rights, and those are life, liberty, and the pursuit of happiness. Our Constitution guarantees those rights explicitly in the text. The Fifth Amendment prohibits the federal government from depriving people of life, liberty, or property without due process of law, and in so many cases, as the chair has recognized, that's not happening. Likewise, the 14th Amendment prohibits states from depriving any person of life, liberty, or property, again, without due process of law. But civil asset forfeiture too often creates an end run around the constitutional guarantee of due process. Too often, civil asset forfeiture creates a seize first, asked questions later approach and incentive. We do want to prevent criminals from continuing to use their property in the commission of criminal offenses and crimes, or to enjoy the property derived from illegal activity. They shouldn't be doing that, obviously. But asset forfeiture pursuant to a criminal charge and conviction is a sound means of ensuring criminals do not benefit from the proceeds of their crimes, and defendants should be proven guilty beyond a reasonable doubt. Civil asset forfeiture is an action against the property, and those property owners who have assets seized have no guarantee to an attorney to help them navigate a very complicated and most often expensive and costly legal proceeding they usually cannot afford to contest the forfeiture in a proceeding in which the government has a very low burden of proof. In fact, it often costs well more for an attorney than the seized assets are worth, leading many forfeiture actions just to simply go untested because it's unaffordable to fight in court. Many innocent activities have led to authorities seizing assets which are often very difficult to get back through any forfeiture proceeding. Small business owners have been wrongly accused of structuring, which is the practice of depositing or withdrawing less than $10,000 to avoid bank reporting laws, even though there are a number of reasons to deposit $9,000 in a bank. Those affected have had their entire bank account seized, tying up all of their operating capital for months, if not years, in complicated legal proceedings, all without ever being charged with a crime. Others have had their life savings confiscated by the government merely for carrying large amounts of cash, again, without being charged with any criminal offense. A report by the Institute of Justice shows the median cash seizure in states is only about $1,300, which is well below the amount of money it would cost to hire an attorney to contest the forfeiture. This is a real problem in our country, one that Congress should seriously debate and consider reforming, which is why we're doing this today, so thank you. And certainly there are simple, common sense reforms that we all could get behind to restore the Constitution's guarantee of due process, some outlined by the chairman this morning. But for example, it should be easier for litigants representing themselves to navigate and contest any forfeiture action. We should guarantee their right to a quick hearing where the government must show cause for why the property was seized in the first place. And we should consider whether it is proper for funds to be returned directly to the authorities seizing those funds in the first place, or whether those funds should be deposited, as you mentioned, in the general treasury, if not returned directly to victims that are affected. I look forward to hearing from our witnesses today, so thank you for spending your time with us and sharing your knowledge and expertise and personal experiences about the scope of this issue across the country and what we could be and should be doing as legislators in Congress to solve it. Thank you, Mr. Chairman, and I yield back.